May it please the Court. I'm Peter KOCLANES with the Attorney General's Office for the state. Elizabeth Marsh committed 4 crimes when she rear-ended 2 teenagers while impaired by numerous controlled substances. She committed DUI with serious bodily injury as to both victims, and she committed DWLS, or driving while license suspended, with serious bodily injury as to both victims. The 2nd District erred in finding that the single homicide rule prohibits double convictions for these classes of crimes. This Court must abolish the single homicide rule in order to properly respect the legislative intent to adopt the Blockburger statute as the default statutory test under the law. Now, let's take a look at the statute. Section 775.021 is a clear and comprehensive statute which abolishes lenity, adopts the Blockburger test across the board, and simply leaves no room for grandfathering a 4th exception that is not listed in the statute. Now, I'll read some excerpts of language from the statute. Whoever commits an act or acts which constitute one or more separate criminal offenses. Now, notice we're using the blanket term criminal offenses, not drawing distinctions based on whether it's a homicide or not, whether there's a serious injury or not. It goes on, such person shall be sentenced separately. So we have a shall that the legislature is mandating that the sentencing shall be separately, although the trial judge has discretion whether to do it consecutively or not. Offenses are separate if each offense requires proof of an element that the other does not. The intent of the legislature is to convict and sentence for each criminal offense in one episode and not to allow the principle of lenity. Now, this language is as clear as it gets in terms of spelling out the legislative intent to abolish lenity and to adopt the Blockburger test as the default statutory test. And this statute creates what I'm going to call 3 problems to grandfathering the single homicide rule, 3 reasons we can't do it. The first reason is the unqualified language, the blanket term criminal offenses, which does not have a parenthesis that says except homicides, and the blanket abolishment of lenity, which does not qualify except for the single homicide rule, and the blanket statement of legislative intent to convict and sentence for each criminal offense. There's no qualification in there about homicides. That's the first reason. The second reason is that the statute explicitly abolishes lenity, and if we look close into case law, we see that the single homicide rule is based on lenity and arose under lenity. In fact, Carawan explicitly identifies Hauser as an application of lenity, and Hauser uses obsolete language that was overruled in Valdez and was only true under lenity. For example, Hauser says that Section 775.021 is just a tool or an aid. Well, that's not true. That was overruled in Valdez.
Well, and if it wasn't lenity, what else could it be?
Well, exactly. It has to be lenity because double jeopardy jurisprudence begins and ends with legislative intent. So you would solely look to the legislative intent, and then only if there was an ambiguity would you use lenity. But there's no room in double jurisprudence for basically a common law sort of fairness doctrine based on judicial equity or something. It's always been all about legislative intent. And the third reason that the single homicide rule is not a reasonably added to the statute is that legislative lists are presumed exhaustive. And this statute contains a list of 3 exceptions, and it states that exceptions to this rule of construction are. It doesn't say include or include but are not limited to. It states exceptions to this rule of construction are 1, 2, 3. So that lines up perfectly with the canon of statutory construction that we should assume a legislative list to be exhaustive and the complete statement of the legislature's opinion on the matter. We would have to ignore all 3 of these problems to grandfather the single homicide rule. Now, any one of these alone, for example, looking at the first paragraph of this statute alone, would be enough to convince some judges to employ a black letter sort of textualist interpretation, and that's what you see in Hauser. Hauser was in 1985 before the 1988 amendment, and even in Hauser you have a dissent who's advocating, let's just strictly apply the statute. The legislative intent is clear to adopt Blockburger. And you have another couple dissenters in Carawan who are advocating the same thing. We should be strictly applying this statute. Now, they didn't win the day until Valdez, when this court finally accepted that this statute is not just a tool or an aid to legislative intent. It is the complete definitive statement of legislative intent. Now, if we look at the statute, it would not be that disruptive or that big of a change to abolish the single homicide rule and employ this Blockberger statute across the board. It already has 3 exceptions, which would naturally limit the way that we could prosecute homicides. For example, if they were lesser includeds of one another, or if they were identical elements or degree variance as provided by statute, the Blockberger statute would offer protection, double jeopardy protection to homicide defendants in that you could not punish those twice. And that would apply to all murders under 782.04 because they would all be degree variance, first degree murder, second degree murder, felony murder. It would also subsume manslaughter because manslaughter is a necessary lesser included of murder. It's a category 1 lesser, so that would be swept up by the lesser included. So the reality is that there would be very few cases in which we could actually prosecute a murder twice. It would have to have different elements, and it would only actually arise in a few sort of traffic crime permutations where there was a different traffic offense plus a death, and if there was a unique element, then it could arise. This case would be an example of charges if there had been a death, but there would not be very many. And if we adopted that position and strictly applied Blockberger across the board, even as to homicides, that would bring uniformity and consistency to the case law and would adopt the simplicity of the Valdez rule even for homicides. Now, the second reason that this court should abolish the single homicide rule is because it is, if we're being honest, a form of lenity.
I'm sorry to interrupt you.
Huh?
But we don't have to abolish the single homicide rule in order to get the result in this case that you want, right? I mean, I understand that there would be tension between what we would have to do in this case and the single homicide rule, but
technically you could evade it by writing a kind of mealy-mouthed opinion that says, without directly addressing whether the single homicide rule exists and not expressing an opinion one way or the other, we find that it does not apply to this. But
I mean, it wouldn't have, I mean, mealy-mouthed. I mean,
well, what I
we
mean
would just
by
say
that,
the single homicide rule applies to homicides, and we would look at this and apply the statute, and
True.
And then in a later case that involved a homicide, then we would have to deal with whether the single homicide rule was actually justifiable.
but if you did it that way, you would be setting up precedent that it still exists as to homicides, and then you'd have to make a more...
Why would we have to, what do you mean we would be setting precedent that it still
Well,
exists?
in the way you phrased it, you said the single homicide rule is limited to homicides.
Well, we would say our case is a deal, that address the single homicide rule, as the label suggests, deal with homicides, and this isn't a homicide case, so...
True, but I think it's still a threshold question. Whenever you're trying to apply a doctrine, they're trying to expand it to this case. A valid question that you can always ask is, does that doctrine even still exist?
We could
the
run a
bottom line-
non-mealy-mouthed opinion that said the issue is still out there, right?
True. And if the court feels that it's not ripe, then the court could do that. However, I do feel that in order to honestly answer the question of, does the single homicide rule apply to this, we can't just say, we kind of have to know our reasoning for why it still exists. If it survived Valdez, what is the reasoning? What is it based on? As you said, if not lenity, then what? Because depending on the answer to what is it based on, that might dictate whether it expands. If it was some independent due process fairness principle, well then the second district might have a point that there would be no reason to limit it to homicide. So you kind of have to examine the foundation of it, and in the course of examining the foundation, you'll not only answer the question of whether...
Unless we just say, well, it's different.
True, and that is something that...
If that's a reasoned way to go forward.
that is a
the
method,
mealy
but
mouth option.
the state would respectfully suggest that in strictly applying the statute, we should not simply kind of punt it for another day and draw a line in the sand saying, well, homicide's different. I think we have to start at the statute and have a very compelling reason not to apply the statute across the board, and that's why, we shouldn't arbitrarily draw a line in the sand for homicides versus other crimes and leave it for another day. Now, this court already essentially held that the statute is to be strictly applied under Valdez. And a reasonable reading of Valdez, although it doesn't explicitly abolish the single homicide rule, a reasonable reader of Valdez could think it probably doesn't survive Valdez. In fact, that's what Judge Badalamenti says in McCullough in his footnote, that he doesn't see how the single homicide rule would be viable in light of Valdez, although he didn't have the authority to go there. It would be this court's job to do that. But given, and there's also language in Valdez, and again, this is just an example that was used in Valdez, it's not a holding, but the Valdez court cites some language from State versus Paul in which they give a list of crimes, theft, murder, manslaughter, and arson, and say, these are examples of degree variance under the second exception. Now that suggests that we are applying all crimes, including murder and manslaughter, applying the Blockburger statute to every crime equally. Because if indeed the single homicide rule existed, why would we ever bother examining the second exception under the Blockburger? Because it doesn't matter whether they're degree variance, it doesn't matter whether they have unique elements, they're always going to be categorically banned by the single homicide rule. Now we're just reading between the lines in Valdez, but a reasonable reading of Valdez suggests that this court has adopted a strict application of the Blockburger statute without any exceptions. So if there are no other questions, I'll reserve for rebuttal.
I was told the clock doesn't start till I start talking, so.
Well, at some point, you, you need to go.
I'm going to go. May it please the court. My name is Lee Levenson, and I am pro bono counsel for Elizabeth Marsh. Elizabeth Marsh was driving. She was not drunk. She had some prescription medication in her, and she hit another car with two teenagers.
She didn't have the benefit of having a driver's license either, right?
She did not have a driver license, so she was driving when she shouldn't have been driving. And she injured two teenagers. Nobody was killed, and we have it on information and belief that they have made full recoveries. Elizabeth Marsh went to the circuit court in Polk County and tried to do the right thing, and she pled straight up to the court. And she was shocked, as I was shocked when I heard about this, when she was sentenced to aggravated circumstances on each count and sentenced to 20 years in prison, 5 years a count, times 4 consecutive sentences. And so she appealed to the second DCA, and the second DCA said that based on the Kelly case and based on Cooper and Chapman, that that was a violation of her due process, her due process rights. Now, the state wants you to takes a position that lenity is abolished. Well, lenity can't be abolished because it's a right that we have under the Fifth Amendment, and it's a right that we have under Article 1, Section 9 of the Florida State Constitution. And this court is the bulwark against the government violating people's constitutional rights. And that's why we're here. The state wants us to, wants this court to abolish the single homicide rule. And this court has, that's the law of the land, the single homicide rule. Now, Kelly extended the single homicide rule to cases where there's serious bodily injury. And the reason this case is before the court, as you know, is because the second DCA adopted that position, and the fifth DCA adopted the position in Lott. In the Lott case, where they said the single homicide rule doesn't apply to that case just because that defendant didn't kill someone. And it's a meaningless, it's really a meaningless distinction, because both statutes, the DUI statute and the DWLS statute, punish for aggravating circumstances and enhance the sentence. And that happened 2 times in this case. It should only happen in 1. So the second DCA said, okay, you can enhance on the DUIs, but to enhance on the DWLS, because it's the same basic wrong, it's the same basic act, you can't do that. So the the court said, we're going to remand to the trial court that that position, and you can sentence her to the 5 years on each DUI, but not to the 5 years consecutive on the DWLS. It was just fundamentally unfair under under her due process rights.
Counsel, I'm sorry to interrupt you there. Why wasn't it error, though, for the court here not to even apply to go through the statute?
I beg your pardon?
The court didn't even, it looks like in their analysis, they didn't even walk through the 775 statute and make an effort to show how their result could be squared with that.
Well, Your Honor, the statute doesn't abolish, contrary to what the state's position, the statute doesn't abolish lenity, and I think that's why the court did that. And I don't know why they made their analysis the way they made their analysis. I haven't spoken with them or anything, but I thought their analysis was more reasonable than the Lott analysis.
But do you concede, though, that if we do apply the statute that we would have to quash this decision?
No. I think that if you follow the statute has in it, let me just find it right here. Um, 775.021 states at subparagraph 1 that when a statute is susceptible to different constructions, it shall be construed most favorably to the accused. That doesn't abolish lenity. That is lenity.
Well,
So
read on. I mean, we understand that the statute establishes a statutory rule of lenity, but the statute specifically addresses the circumstances in which the rule is not to be applied when the legislature has decided that in one criminal episode there are acts that violate separate provisions of the statute, of the statutes. Isn't that correct?
It says offenses which are lesser offenses, the statutory elements of which are subsumed by the greater offense. And if you're referencing that, that is clearly what happens in a DUI, DWLS. Any of us who have served as public defenders or prosecutors know that. And so it's treated with in the statute.
But these offenses are entirely different offenses. The DUI is one thing. The driving without on a suspended license, that's an entirely different thing. I mean, there are two different things the legislature is trying to proscribe. And they're entirely distinct. It's not like they're, one is subsumed by the other. Because they're entirely different. I mean, this would be sometimes maybe there'd be some argument that even if it's some different place in the statute that it would be subsumed. But these are different. The conduct is entirely different. It may get rolled in to one sequence of events.
The conduct is the same. They're driving when they shouldn't be driving.
Well, I think the legally relevant point is that the DeWillis charge has a suspended license, driving with a suspended license, and that's not part of the separate charge of the DUI with great bodily injury, correct?
That is correct.
Okay, and then the DUI with great bodily injury has the element of impairment, which is not a part of the separate crime of DeWillis causing great bodily injury, correct?
They share. There's
no impairment requirement for the DeWillis charge.
Correct.
Okay, so they're separate crimes because the legislature has defined different conduct as part of each separate crime. I mean, that's what legally distinguishes them as separate crimes, correct?
Yes, Your Honor.
Okay, so and you understand that if you go through the 775 analysis, that because they each have elements that the other doesn't have, that they qualify for punishment, even though it was the same occurrence or transaction. I mean, that, you recognize that, right? I mean, there are plenty of cases that interpret and apply the statute, and all of them do it that way.
I have, let me see here. In Valdez, which this court decided in 2009, this court said that the court should not mechanically apply Section 775.0214 so as to obtain unreasonable results. And the court went on to analyze 775 and stated that the statute itself creates an exception for crimes that are degrees of the same offense as provided, but the court doesn't apply it mechanically, even though the elements might be slightly different. It's the court talks about, by its very language, this exception is intended to apply narrowly. It prohibits separate punishments only when a criminal statute provides for variations in degree of the same offense, so that the defendant would be punished for violating 2 or more degrees of a single offense. But then it goes on to say that it's not necessary for the legislature to use the word degree in defining crime in order for the degree variant exception to apply.
Well, are you contending that the degree variant exception applies here?
No, but I think the reasoning. I think that the reasoning applies here, and this court, at least in 2009, did not want to mechanically apply 775 in a way that would get unreasonable results. And also, I think it's...
I'm not sure exactly what that means in this context.
Unreasonable results.
Well, mechanically apply. I mean, there are 3 exceptions to the rule that multiple convictions arising out of the same criminal episode are to be punished separately. There are 3 exceptions. And we've already talked about exception 1. These are not offenses which require identical elements of proof, correct?
Yes, it's not.
Okay. Exception 2, you just said that you're not contending that these are degree variants, so that would be exception 2.
Yes.
And then offenses which are lesser offenses, the statutory elements of which are subsumed within a greater offense. You're not contending that it's that exception.
I'm not, but it also...
Okay, so we've just not mechanically applied, but just looked at the exceptions, and you've conceded that these separate crimes don't fit any of the 3 exceptions. So,
but the statute also leaves open if there's ambiguity in there to decide those.
Where's the ambiguity?
I think that there's an ambiguity in the word subsumed, and that's what the court talked about in Valdez. And it says, for example, it talks about how you don't have to have fit into one of those 3 categories that you were just talking about, Your Honor. It says that,
the
for
only
example,
time the word subsumed appears in the statute is the 3rd exception, offenses which are lesser offenses, the statutory elements of which are subsumed by the greater offense. How is the word in context in any way ambiguous, relevant to the question that we're looking at?
It's not, but when we interpret a statute, we have to try to harmonize it with constitutional jurisprudence. And this court can't be bound by the legislature to do unconstitutional things or to bless.
On that point, where is it written that due process requires lenity? Where is that principle established? Where did the U.S. Supreme Court pronounce that? Or where did we pronounce that?
The United States Supreme Court stated that in United States versus Wiltberger. Chief Justice Marshall justified the rule of lenity on grounds of constitutional rights and structure, legislative supremacy. And that means that before we'll let a legislature...
supremacy.
That doesn't mean the legislature is the king or can do unconstitutional things. What it means is that when we're looking at laws, we try to interpret them and harmonize them with the Fifth Amendment, say, or Section 1, Article 9 of the Florida State Constitution. And if 772 is butting up against that, it's unconstitutional. And this sentence is unconstitutional. The legislature isn't your boss. You're the boss.
So, okay, are you making a constitutional double jeopardy argument or due process argument?
They're related, but it is double jeopardy is based in, as you know, due process. It's the same fundamental fairness of notice, statutory notice in this case.
But doesn't the jurisprudence make clear that if the legislature wants to impose multiple punishments for a single course of conduct, because they're trying to vindicate different policy objectives, that they're free to do that, and that does not violate double jeopardy. It's just that they have to actually do it, and it can't be. We've got to know that they're doing it, But doesn't that fairly sum up the double jeopardy jurisprudence when it comes to legislative power?
No, I don't think that's a fair. I don't think that's a fair analysis because, I think this court got it right in State v. Cooper, 634 Southern 2nd 1074, where
But
this
aren't
court,
all
this
those
court
cases
ruled where it's
really about what
impermissible.
we're an assumption about what the legislature intended? Doesn't that case really, that whole line is based on an assumption about legislative intention, not based on a constitutional restriction on legislative power?
It is, no, it's based on also telling the legislature that you can't punish the same injury twice. You can't punish for the same injury twice. That's the basis for the single homicide rule as well. You can't punish someone twice for the same death. And that same analysis applies to a serious bodily injury. You can't punish a serious bodily injury twice, and that's what's happening in this case. Does anybody have any more questions? I know you're against me. But I
These
found
questions are sometimes just rhetorical questions.
No, I don't think so.
I said sometimes. I did say sometimes.
You began and ended with unusual candor. We appreciate that.
And appreciate your pro bono service.
We thank you. And we thank you.
Okay, thank you, Judge.
I'll just make a few brief points. I did have one thought regarding why you should address abolishing the single homicide rule now rather than wait later. And I think the reason is that if the court determines it is an error and agrees that it was error to keep the single homicide rule because it's completely outside of the Blockberger statute, that's the error, that we're just sidestepping the statute, operating outside the statute, and ignoring the connection in lenity, which was abolished. If the court agrees that's an error, the court should not wait because as of now, the DCAs are still bound by Cooper and Chapman. So if you wait 3 years for a case that comes along 3 years from now, the DCAs will continue doing erroneous decisions for 3 years. And not only will that deprive the state of the correct law in those cases, it'll deprive the state of the ability to use the Blockberger test in those cases, and it will deprive the legislature of its right to have the correct law applied during that 3 years. And it will also, generate more incorrect case law, which may have an effect on stare decisis. It wouldn't necessarily mean we have to keep the single homicide rule, but the defense attorney 3 years from now will be able to argue, well, it's been 13 years since Valdez and we haven't overturned it yet. Whereas now it's only been 9 or 10 years since Valdez. So there's less deeply rooted, sort of erroneous case law, and it would be easier to pull off the Band-Aid now than 3 years from now. Now, Florida State is kind of unique in that we've adopted the Blockberger test statutorily not once but twice. The legislature passed it in 1983, the first paragraph, and then they passed an amendment in 1988 making it 100% clear that this is not just a tool of statutory interpretation. This is the clear, precise statement of intent. So Florida's test is not just a tool of statutory construction. It's a mandate to impose dual punishment whenever the crimes have unique elements or do not satisfy the statutory exceptions. And there's no reason to assume a single homicide rule exception to that. And my final point is that it doesn't really make sense for the legislature to not intend to punish homicide twice in light of what they do intend in Blockberger. You could view Blockberger as kind of a rule of severity, that if a crime has a unique element, regardless of what the other elements are, regardless of whether it's the same evil, if it has a unique element and doesn't apply for these exceptions, you can punish it twice. That's a a strict and severe rule, although it still gives the judge discretion not to sentence consecutively, it increases the statutory max. If that is their intent with every non-homicide crime, as it clearly is under Valdez and under the statute, why would they intend to exempt murderers and give murderers a more merciful, lenient, one kill, one conviction rule? We don't apply that merciful rule to child molesters or rapists or arsonists. All of those other non-homicide crimes are subject to a strict Blockberger. So it doesn't make sense for the legislature to have two states of mind, a strict Blockberger as to non-homicides and a merciful, archaic, common law double jeopardy
and
test.
is there any potential textual basis for finding such different states of legislative mind on this?
Absolutely not. Absolutely not. It really just comes from the Chapman sort of phrase, putting words in the legislature's mouth. It essentially adds words to the statute, but they wouldn't have intended to punish homicide twice, which, as I argued in the reply brief, is really just a way of saying under lenity we would have presumed that, but that was only true in the 1970s when we were operating under lenity. We can no longer assume that after the 1988 statute.
This is not legally relevant to the issues that are raised, but I'm just curious, do you agree that this is an unusually harsh sentence?
Not under these facts.
Okay.
I think that this gives the trial judge the discretion to make the call, and the elements of this crime don't even reflect some of the aggravating facts that were brought out at sentencing, such as this was her third DUI. That's not even an element, so that's not reflected as part of the aggravating factors. And the trial judge was there to see her extreme addiction. He obviously didn't see any end in sight, and the fact that she was warned twice not to drive, twice her keys were taken away, and she continued driving. I mean, he basically saw a woman who was out of control and might very well take someone down with her in the course of driving, and almost did with these two kids. So this is reasonable, and obviously the victims' families expressed that they thought that the state's initial 10-year offer, which did not get accepted, was too light. The victims' families wanted severe, serious sentence and didn't even want restitution. So they were happy with this 20-year sentence, and in his discretion, the trial judge was within the statutory bounds, and it was a reasonable sentence. So we would ask you to quash the Second District's opinion in Marsh and reinstate all Marsh's original convictions and sentences. If there's no other questions, thank you.
All right, well, we thank you both for your arguments, and the court will now stand in recess for about 10 minutes.
All right.